As far as the forensic accounting goes, I agree. Under Rule 53, it's tenuous, Your Honor. I believe that Rule 53A1B could allow for the appointment of a special master here to address pretrial matters that can't be timely and effectively addressed. I think there's some relief there. I believe the rule may have been amended in 2016. But, you know,
but really, I view that rule as more of like when you have, you need voluminous documents reviewed for privilege or something like that. I don't view it as appointing essentially an independent expert to do forensic accounting.
And Your Honor, you know, I sort of agree, but, you know, the rule states that the court may appoint a master to hold trial proceedings or make or recommend findings of fact conclusions without a jury. I understand that, and this is a jury trial, on the grounds either that there is some exceptional condition or the need to perform an accounting or resolve a difficult computation of damages. So, I mean, that's kind of the basis or the hook that I thought the rule may be applicable here. We cannot, and I've consulted with 3 separate forensic accountants in this case, Your Honor. And with how he described the incomplete records and the way that this is all like money order, you know, Western Union, ATM withdrawals, and it's just the accounting is just all over the place. He testified he commingled every bank account with business and personal funds. It's truly impossible to untangle this web of transactions, even if we hire a forensic accountant and they spend 300 hours on it. So
then why would I appoint one if it can't be done? Why would I appoint one to do that?
Because it needs to be done with Naram Danka's with his authority or his collaboration, at least, because he's the only one who can explain all these transactions. So if I hire one, how can I get him to explain all of these transactions when Naram Danka can't do it? And at minimum, Your Honor, if you don't like the Rule 53 vessel, which I don't necessarily love it either, I'm looking for anything that may be applicable in the rules to remedy this misconduct. We at least would like an accounting. You know, there's never been an accounting from NAD. He's testified there was never an accounting. We're talking about tens of millions in transactions and revenue. And that's why I brought up the tax issue. Only 1 or 2 bank accounts were disclosed to their accountant when 6 exist. And there's no ledger, there's no QuickBooks, there's conflicting profit and losses only for 1 year. So this company just has no accounting, and it hasn't really reported it, you know, to the proper authorities what the accounting was. So I'm looking just for either a special master if the court finds that procedure to be helpful in a situation like this, which if it doesn't, I understand that. Alternatively, to pay for an accounting at NAD's expense, because Mr. Takir should not be forced to pay this for a company in which we allege he's a 50% member, and there's been no accounting to determine what his profit is. Meanwhile, the other member is taking millions or hundreds of thousands in ATM withdrawals. I just feel like that's an appropriate remedy in this situation. But you know, I'm happy to talk through the forensic accounting more if Your Honor is interested in potentially that type of relief and how that might look. But at minimum, you know, the deadline, as the court knows, with the motion to extend that was disputed, is in about 2 weeks. I've been trying to get in a position to where we can figure out how this can be done. And I was hoping to get some maybe clarification or insight from the court of whether it's leaning one direction or the other, so that I have to determine whether to move to extend that deadline again.
Okay, we'll circle back on that. Okay.
All right. Yeah, I mean, that really sums it up, Your Honor. If you want me to go through the rules or the Marquez v. Ortega factors, I can, but you know it. You know the rules, and yeah, I don't want to waste any more time. I just want to reserve some time for rebuttal. Like I said, just to sum up, I mean, this is not standard supplementation. This has been really material and egregious discovery reviews at great expense to my client. I hope at minimum we can compensate him for that time and expense. Thank you.
Okay, thank you. Mr. Weichert.
Thank you, Your Honor. And, you know, again, I don't want to get in the background either of this case, but, you know, since plaintiff brought it up, you know, he's claimed this as a simple business dispute. From the get-go, we've argued this was never about, you know, whether he needs to be paid out or not. We allege he's not a member. The first agreement he talks about was not signed. You know, there's no counterpart agreement. It was a simple one line. It wasn't signed. It wasn't notarized by his client. It was produced pretty far into litigation, the signed version by his client. And these 4 witnesses that were there were all associates of Tahir. Our client's going to testify that he felt threatened when he signed this document in Iraq. Or sorry, when he signed the second agreement. But then again, there's a second agreement that he did sign in Iraq, but by plaintiff's own translated document, it states it's an investment agreement. It does not even reference NAD or Al Rawi. So these two documents are conflicting. That's all the background I want to give on that. Again, we've disputed that he's a member from the get-go. And that kind of goes into the accounting and all these bank records. Yes, our client can't account for every withdrawal he's made over the course of the last 7 years because it's a sole member LLC. He has commingled his personal funds with his business accounts. And obviously, he's not going to be able to account for every single withdrawal, just like you or I probably would not be able to do over the course of 6 years. And plaintiff similarly assumes that any account identified later must have been intentionally concealed. One of the accounts was inactive, and Mr. Donka understood the request is seeking accounts actively being used. And these responses were supplemented once, they were discovered. And in more recent records, Mr. Donka has been stuck in Iraq since February. He has not been able to leave because of the Iran war. He's in Erbil, Iraq.
And I read that, but he doesn't need to go to the bank to be able to get the account records. He can do that remotely, presumably, correct?
He actually had two of his banks request that he be in person to get all of the full records, other than just a simple transaction log.
I didn't see any reference to that in the response.
It might not have been in my response, but when I spoke to my client, that's what he informed me, that he's not able to get them, overseas, basically. That he was requested to be in person to get the full account recording.
Okay, go ahead.
And then as far as the deposition costs, I don't understand why deposition costs would have to be, awarded or sanctions for that. Mr. Donka is unquestionably going to be deposed regardless in this case. He's the main defendant. That deposition was not limited to these bank accounts. So it did come out that there were additional bank accounts at that that deposition. But again, that deposition was not limited to discovering new bank accounts. As far as subpoenas, I don't see the prejudice there. Once he discovered those new accounts, he filed the subpoena pretty much immediately, plaintiff, and we didn't really have a chance to get those records, supply them. I mean, again, I will admit that they were disclosed late, but we were never even given the opportunity to disclose them before subpoena went out. And as far as the spoliation and, adverse inference, he's claiming, I know part of his motion was that the electronic bank records were lost or destroyed by our client, but that doesn't make very much sense because they were subpoenaed by the bank. The bank had them. The bank were the custodian. Our client was not the custodian of his bank records. And that goes into a lot of the records that he has. I mean, I don't disagree with the point that some of his accounting is confusing. Our client's not sophisticated. He's operated, again, as a one-man operation. He does not keep detailed records. So a lot of those, we just thought there is no records.
Let me ask about that, because I understand your position that the rules don't require your client to create documents that don't exist. But at some point there was a litigation hold, and it seems like there ought to be some source documents, whether he's creating a ledger or a journal, whatever it may be. What about the source documents themselves? Was he not keeping those? So if he's taking a withdrawal out of an ATM or something like that, is he not keeping any records of that?
No, Your Honor. And as far as a lot of the auctions, the car auctions, he kind of just relied on them to maintain the purchase history for him. And if he needed it, he would request it. But, again, he doesn't keep records of this. And it goes into some of his tax records that show that he filed them late. He doesn't keep a good accounting.
Even while this dispute has been going on. So, I mean, is he still not keeping any records?
I believe he's conducting business as he always has. He's not, because he wasn't creating these records to begin with or keeping them himself.
Okay, go ahead.
And then as far as I'll just quickly touch on the tax return. I know that was disclosed late, but our issue there was we were waiting for the IRS to confirm whether he filed or not. Our client couldn't remember. He filed a request with the IRS, and once we got the confirmation that he never filed in his compliance report, we sent it over to plaintiff. So again, we were waiting to have an actual formal document before just saying you didn't file them. And then just kind of lastly, touching on the forensic accounting, I don't believe that's appropriate. I think plaintiff is using this as a vehicle to get our client to pay for his expert. You know, the rules and case law will contemplate if you have an incomplete record, you should still retain an expert and get a report that can be supplemented later, rather than waiting until the deadline to ask to extend. And then once you get that extension, we get to this hearing asking our client to pay for all of that. That just doesn't make sense to me.
Hey, anything else?
No, Your Honor.
Okay. Sir Tuxedo.
Good morning, Your Honor. All right. First, I would like to clarify one point. The NINA defendants are fully separate and distinct from the NAD defendants. So this is a clarification that I want to make because it's a line that tends to get blurred a lot by plaintiff, not just in this motion for sanctions, but throughout these proceedings as a whole. Nina Wadanka and Nina Cars LLC are completely separate individuals and entities from Naramson Danka, NAD, and L Rawi. They're separate and distinct. Here, a lot of the conduct that plaintiff is alleging was performed by the NAD defendants. He is blurring that line to try and impose these sanctions against the NINA defendants as well. I wanted to bring this up so that way I could point out the only specific issues that were pointed to the NINA defendants in this case. Namely, plaintiff alleges that he had to disprove the NINA defendants' original discovery responses and that he had to do that through a subpoena and through Nina Wadanka's deposition. This claim is fully disingenuous. Arizona Rule of Civil Procedure 26G requires that any party who has responded to any discovery request supplement it if they become aware that it was incomplete or incorrect. In this case, as soon as Nina Wadanka and the NINA defendants became aware that their original discovery responses were incorrect due to a mistranslation and her issues with understanding English, the parties immediately spoke. Myself and Mr. DiPiero spoke, and we agreed that we would supplement the discovery responses. Less than 30 days later, those discovery responses were supplemented. Similarly, the parties were speaking regarding obtaining the bank records that Mr. DiPiero believes he is entitled to recoup the cost of subpoenaing. Prior to that subpoena being issued, the parties were operating in good faith and working to obtain those documents independently of any subpoena. Prior to my client being able to obtain those documents, though, plaintiff decided that he wanted to subpoena in order to expedite. We did not object. We decided, okay, that's fine. We were in the process of working in good faith to get those documents, and we were working together on them. We agreed to supplement our discovery responses. We did it within the time required, and we were working to supplement and get the additional bank records. Throughout this entire process, the NINA defendants have routinely operated to try and resolve these discovery disputes without involving the court and operating in good faith to try and smooth all of these out. Plaintiff is now using those good faith attempts as an excuse to try and sanction us for his own choice to go and subpoena those documents. The notice that they provided regarding reserving the right to any sanctions and costs and fees was provided a month and a half after the supplemental responses were sent. Again, the supplemental responses that were agreed upon by the parties. Additionally, the claim of plaintiff that the deposition of Nina Danka disproved her original discovery responses is fully disingenuous. That deposition occurred 3-4 months after the discovery responses were supplemented, again, at the agreement of the parties. The parties agreed that we've sent you the emails where we discussed the deadlines, where we discussed when things would be coming forward. Some of the relief requested by plaintiff is pursuant to Rule 37B. Most of that does not apply to the NINA defendants. The NINA defendants have not been subject to any discovery order in this case. We have not been before you on any discovery disputes, and we've routinely operated in good faith to resolve these issues without involving you and to expedite these issues at every step and turn. Plaintiff has gotten impatient at some points and decided to issue that original subpoena. That's not grounds for sanctions. The parties worked in good faith, and there's no good faith grounds for sanctions as it relates to the NINA defendants. I wanted to point out that blurring of the lines early on, though, because a lot of the claims that plaintiff makes as to the NAD defendants, he routinely uses the phrase defendants, trying to allege that the conduct was performed by both the NAD defendants and the NINA defendants. The NINA defendants acted as I've just laid out for you. We supplemented our discovery responses pursuant to Rule 26 at agreement of the parties, and we were operating in good faith to obtain the bank records that plaintiff went out of their way to subpoena. And when plaintiff requested the subpoena, we decided not to object in order to expedite everything and continue operating in good faith. That's all I have, Your Honor.
Okay, thank you. Mr. DePiro, a brief rebuttal.
There was a lot there, Your Honor. I'll just try to go through this as quick as I can. I'll start from back. What Nina Cars just described as, they were working on getting the bank records, that doesn't match what the record states. They said the company never conducted business in RFA in their discovery responses, and they submitted incomplete bank records. We realized they were incomplete, and we subpoenaed the bank to disprove it. That turned out that it had conducted business, $150,000. It's extreme material omission that they had there, and it was misleading. So, and that investigation was caused by their discovery misconduct. It's fully sanctionable in my view. It was only after we told them through our investigation that they supplemented. And then we had to further clarify that during the deposition. We had to go over the bank records with her, have her explain what certain transactions were. And she testified at the deposition that she didn't really know how to run the company at all. She knew nothing about cars. She had only driven a car before. And you're talking about a very sophisticated business where you're like shipping cars overseas, dealing with regulatory authorities, like finding buyers in different languages, all kinds of things. It's very sophisticated. The argument is that was just a puppet from Naramson Donka. So to say it's totally separate, I think that's a bit disingenuous, but we can deal with that issue at trial. It's certainly the information was discoverable and relevant. And just so the court's aware, Mr. Donka is paying the legal fees for both brother Donka's, sister Donka's defendants, and actually claiming it on taxes, which I thought was improper, but it's neither here nor there. Going back to Mr. Weikart's point on the supplementation of an expert issue, I think that was largely addressed in the motion to extend that the court granted, but just briefly, as I put in the motion, you can't do a forensic accounting if you're missing 3 critical bank accounts. It's just, why even do the work? How can you determine what profit is when you're missing millions in transactions? It doesn't really make sense. It would be an extreme waste of resources. The filing of the tax records, I don't know if the court's aware, but just to bring it in the forefront, Mr. Donka filed 2022, 2023, and 2024 in September of last year. But after litigation began, presumably after realizing he never filed any taxes, maybe on advice of his attorney, he went ahead and filed 3 years worth, got it all together and just filed it. So at that time, I'm sure he knew 2021 you didn't file for, but I'm not going to insinuate, just wanted to bring it to the court's attention. I think another one of Mr. Weikart's argument is, well, he's been in Iraq since 2026. He has hard trouble getting access to the bank accounts. First of all, I don't know if, I think you just send a request to your bank, but separately, these requests were issued in September. And so he had 6 months in the US to provide responses, and he didn't. He misled and didn't provide basically anything. With respect to spoliation, yeah, I'm primarily I think the court gets that. I'm not going to go over that one. The spoliation, he's not even preserving any evidence after the lawsuit began. It definitely arose when the parties were disputing in the end of 2023, and then there was a preservation notice the following year. So at least as late 2024, everything should have been preserved, and it wasn't. And then finally, like I said, Your Honor, with the China doll affidavit, I think all those issues can be addressed there. But for the deposition, we had to, at the deposition is when we found out Al Rawi had conducted business. So of course, so many questions, arise out of that. in addition to trying to get information about these bank accounts, the finances, which don't make sense because of the incomplete records. I believe it's fully recoverable, but I'll leave that to Your Honor at a different time. That's all I have unless you have any other questions, Your Honor.
I do not. I will take the motion under advisement and issue a ruling in due course. You wanted some guidance, Mr. DePiero, about, remind me again what it was?
The expert disclosure deadline is in 2 weeks. I don't know what the court wants to do with that. I'm, at the court's good graces here to get some guidance on whether you would want us to extend that while the court determines, the ruling on this motion, if it would grant an extension or if there's any other, sort of avenue to get some clarity there.
Is there any agreement on extending the expert disclosure deadline?
I don't have any. I don't have any with that.
Mr. Weichert?
No, Your Honor, because our point stands that they should have produced an expert report with what they had and then supplemented.
Okay, I will address that issue when I rule on the motion.
Okay, but again, Your Honor, the deadline's in 2 weeks. Do you expect to issue a ruling?
No, it's doubtful, but I can always extend a deadline if I find that appropriate. So I'll address that issue when I rule.
Okay, thank you, Your Honor.
Okay, thank you. Have a good weekend.
You too. Bye.
Thank you.